Hello guys. Hello guys. How are you? I'm Bodrujaman. Today I will try to discuss about the principles of environmental law, how environment is regulated through some sort of law. Today I will try to present it. And before I start, I may say to you, please subscribe my channels and click the bell button for further updation of this video. So let's go to my lecture. So first we try to define what is international environmental law. So the first point is that it is a complex and interlocking bodies of statutes, common law, treaties, conventions, regulations, and policies. And environmental law aim to regulate. It's an environmental law operate to regulate the interaction of humanity and the rest of biophysical or natural environment. The purpose of environmental law is to reduce or minimize the impacts of human activity both on the natural environment for its own sake or on humanity itself. So now we'll try to discuss the area of concern where in which point the international environmental law try to discuss and try to focus. First we'll see that the air quality and water quality, because it is very basic for our living, our survival. Then the global climate change, because of the global warming or other things, the climate is getting changed day by day. That is a major concern of international environmental law. Then for our food security, agriculture, biodiversity, and species protection, because the university is not only for humankind. There is other species who living in this plant. So environmental law also focus on this diversity and species protection. The next is pesticides and hazardous chemicals. For the production of food, we use pesticide and hazardous chemicals, and they also focused on this. And this law also also take necessary steps to minimize the waste, and to provide a regulation how to manage this waste and recommendation, and how to remediate this contaminated waste, and the management of public lands and natural resources. These are the areas where environmental law try to look upon. And now we'll try to uh, look the treaties, because the environmental law is basically coming from coming from a binding source, through the international conventions, which we may call as treaty. So we will discuss some sort of treaties which contribute largely to the development of international environmental law. First, the Vessel Convention on the Control of Transboundary Movement of Hazardous Wastes and Their Disposals in 1992. It is the most comprehensive global environmental agreement on hazardous and other wastes. The aims of this convention is to protect human health and the environmental agents' adverse effect of hazardous wastes. There is three aims. First, generation and management. Second is transboundary movements and the disposal system. And the next treaty is the Convention on Biological Diversity. It resulted from the recognition that the damage to biodiversity can only be effective dealt with in a comprehensive manner. There, there are three main objectives of Convention on Biological Diversity. First is conservation of biodiversity. Second, sustainable use of its component, and fair and equitable sharing of the benefits arising from genetic resources. The next, the next convention is on the international trade in endangered species. It is an international agreement between governments, and its aim to ensure that international trade in specific specimens of wild animals and plants actually does not threaten their survival. The next one is the Convention on Migratory Species of Wild Animals. It's can be called as a Bond Convention. It's aimed to conserve terrestrial, marine, avian migratory species throughout their ranges. It's aimed to conserve population of European bats and Black Sea and contiguous Atlantic seas, small cetaceans, Baltic, and seals in the Wadden Sea, albatross and petrels, gorillas in their habitats. It's just such population, in such wild animals, they are on their own to preserve. So, and the last convention on climate change, what is called United Nations Framework Convention on Climate Change (UNFCCC). It considers what can be done to reduce global warming and to cope with whatever temperature increase are inevitable. The key point of this UNFCCC first is to keep maximum temperature rise below 2 degrees Celsius. The commitment to least development countries emission reduction targets and mitigation action by developing countries for 2020. Mechanism to support technological transfer and forestry. So these are the convention which largely helped or contributed to the development of international environmental law. Now we'll try to focus upon the what are the principle of international environmental law. So the general principle and rules of international environmental law that have emerged from international treaty, what I said before, an agreement, and also from customs. The significance of the generality of these principles is that they can be applied to the international community for the protection of the environment. From the large body of international instruments dealing with environmental issues, it is possible to point out seven principles from above discussion or above convention. First, sovereignty and responsibility. Second, principles of good neighborliness and international cooperation. Third, principles of preventive action. Fourth, precautionary principle. Fifth, the duty to compensate for harm. Principle of common but differentiate responsibility. And the last is the principle of sustainable development. We'll try to give some sort of discussion, some sort of brief discussion about every principle. Let's do it. First, on sovereignty and responsibility. In international environmental law has developed between two apparently contradictory principles. First, states have sovereignty rights over their natural resources, and the second says that the state should not cause damage to its environment. But national sovereignty over natural resources has been affirmed in international agreements. By the way, according to Rio Declaration in 1992, the concept The concept of sovereignty is not absolute and is subject to general duty not to cause environmental damage to the environmental of the other states or the area beyond the state's national jurisdiction. The duty to avoid environmental damage also has been accepted in international treaties as well as in international practices or customs. In those areas beyond the limits of national jurisdiction, such as high seas, the applicable concept is not one of the sovereignty, but is one of the common heritage of humanity. The next principle is principle of good neighborliness and international cooperation. The principle of international cooperation places an obligation on states to prohibit activities within the state's territory that are contrary to the rights of other states and which could harm other states or other inhabitants. The principle of good neighborliness is closely related to the duty to cooperate in investigating, identifying, and avoiding environmental harm. Most international environmental treaties have provisions requiring cooperations in the generation and exchange of scientific, technical, socio-economic, and commercial information. And finally, when one state is acting in the territory of another, notification and consultation isn't enough. Prior information consent is required. This consent is mandatory in activities such as transporting hazardous wastes through estates. And the next principle is the principle of preventive action actually. The pollution preventive principle should be differentiated from the duty to avoid environmental harm. Under this new rule, a state may be under the obligation to prevent damage within its own jurisdiction. Action should be taken at an early stages to reduce pollution rather than waiting to restore contaminated areas. To issue to ensure this principle, states have established authorization procedures, commitment to environmental standards, ways to access information, and the use of penalties, and the need to carry out environmental impact assessment or EIA. The preventive principle has been supported by international instruments preventing the introduction of pollutants and also by agreements in the field of international economic law. And the next principle is precautionary principle actually. Since the scientific certainty often comes too late for the politicians and lawyers to protect against environmental danger, the burden of proof is switched to wait for scientific proof regarding the impact of pollutants discharged into the government environment could result in irreversible damage to the environment and human suffering. Traditionally, states wishing to adopt certain protective measures had to prove beyond a doubt that the hazards and the urgency of desired action. Fortunately, because of the precautionary principle, this traditional view of burden of proof was reserved so that a state would not have to wait proof of harm before taking action. And the next is to duty to compensate for harm. The definition poses three problems in relation to international environmental law. First, what is the criteria for imputing liable to the state? Second, what is the definition of environmental damage? And third, what is the appropriate form of reparation? When regard to the first question, there are So with regard to the first questions, there are three options: fault, negligence, strictly liability, and absolute liability. And as the second question, environmental damage has been defined as any injury to natural resources, as well as degradation of natural resources, property, landscape, and environmental amenities actually. But finally, the essential principles contained in the actual notion of an illegal act is that reparation must, as far as possible, without all the consequence of illegal act. And the next is the principle of common but differentiate responsibility. The protection of the environment is a common challenge to all countries. This principle was acknowledged in the Rio Declaration at Principle 4 and 7. The first is the common responsibility of the state of the protection of the environment. This signifies that a state should participate in the world effort for conservation. Second, element of the elucidation of different circumstances of states. For example, industrialized countries have contributed more to the global warming than underdeveloped countries. And the last principle, there is principle of sustainable development. The principle of sustainable development was defined by the 1987 Brundtland's report and as a development that meets the present needs to the present without compromising the ability of future generation to the meet of their own needs. Sustainable development prompts that primary focus of environmental protection efforts is to improve the human condition. Sustainable development, as reflected in international agreements, encompasses at least three elements. First, intergenerational equity, sustainable use of natural resources, integration of environment and development. So, friends, that is this is all about international environmental law and its principles. So I may invite you my next video, and friend, you please subscribe my channel and click the bell button for future video and support me. Thank you.